In this session, I will explain to you how to answer questions on law of agency, particularly for Law 416. And this can also be applied for any courses of business law. First of all, when you are faced with a question on law of agency, what you have to do is that you must remember the scope of the chapter on agency. Now, you must have in mind the overview of the whole chapter. Now, basically, for this chapter, there are four main parts. Firstly, the formation of agency. And under the formation of agency, there are 5 ways in which the agency can be created or formed: express appointment, implied appointment, ratification, necessity, and estoppel. The second part or subtopic of agency is regarding the classification of agency. And this is regarding the powers of the agent, the functions of the agent, and the effects of contracts made by the agent. Either the agent is a named or disclosed or undisclosed principal. The third part or subtopic of the agency is duties of the agent and duties of the principal. And finally, termination of agency, whether it is by the act of parties or operation of the law. So when you have this in your mind, then when you are faced with a question, now you must know which scope, which part, which subtopic is the question about. So if the question is on formation of agency, now you must ask yourself, now which method of formation of agency is relevant? Because when you identify which method of formation of agency is the relevant one in the question, then your answer will be focused on that particular part of formation of agency. So you will not go off tangent, you will not explain about things which are not relevant. And if you do that, if you explain things which are not relevant, then you're wasting time, especially when it comes to examination or test. You need to utilize whatever time that you have in order to answer the question in the particular scope, within the particular scope of the question. So which method of formation of agency is relevant in this question? Is it agency by ratification? Is it agency by necessity? Is it agency by estoppel? And so on. Secondly, you have to ask whether the conditions are fulfilled in this question. So you have to read the question carefully and see whether, now if, let's say for example, agency by necessity, there are conditions to be fulfilled. So you must read the question and pick out to see whether or not the conditions are fulfilled. Likewise, if the question is on agency by ratification, are there any conditions which have not been fulfilled? So you've got to go through the question and find out whether these conditions are fulfilled. Thirdly, what is the effect of the action taken by the agent or this person in this question? In order for this person to become an agent, of course, if there are conditions to be fulfilled, he must fulfill the conditions. But what happens if he did not fulfill the conditions? What's the effect of the action that he has done? Or if the conditions are fulfilled, again, what is the effect of the action? Is the principal bound by those actions? And of course, at the end of the day, we want to know whether claims can be made if the principal has suffered any losses, or if the agent himself has suffered any losses or incurred any expenses. Can he make any claims against the principal? So these are the things that you need to address. When you are answering the question, you need to have all these questions in mind, because these are the things that you need to write in your answer. So let's say, for example, this is a sample of a question. Let's go through the question. Ali instructed his assistant Abu to buy 3 laptops, 1 printer and 1 photocopy machine for his new office. Ali gave Abu a budget of 25,000 ringgit for office equipment. Abu ordered office equipment at a total price of 40,000 ringgit and did not use Ali's name to contract with the supplier Chong. Ali was upset when Abu told him that he has to pay more than the budget given earlier. Ali wants to know if he can refuse to approve the contract which Abu made with Chong. So you're supposed to advise Ali regarding the liability, his liability in this particular situation. So first and foremost, when you look at the question, now you've got to pick out the important points. Now Ali instructed his assistant Abu. So this shows that Ali is the principal and Abu is the agent. Now he has given a budget of 25,000 ringgit. So this shows that there is a limit as to his authority that he gives to the agent. And what the agent did, what Abu did, was that he purchased or he ordered office equipment a total price of 40,000 ringgit, which is exceeding the amount given by Ali earlier. So this should give you an indication, it should give you a clue as to which method of formation of agency this question is all about. He exceeded the authority. So when he exceeded the authority, basically the principal has a choice either to approve it or not. If he approves it, then there is agency by ratification. But if he does not approve it, well, basically there is no agency by ratification created and the agent will be liable, or rather the other person, now he doesn't become an agent, therefore that person will be liable. So what are the points that was stated in this question? Now he did not use Ali's name to contract with a supplier. So he contracted in his own name. So when Abu does that, he is not representing the principal. Remember, one of the conditions for a valid ratification is that the agent must not have contracted in his own name. So in this situation, since Abu did not fulfill that requirement, now Ali cannot ratify the contract that Abu has made with Chong. So how do you answer the question? Now first and foremost, you must write your issue. Now in order to write a proper issue, there are certain keywords that should be in the issue. For example, the word formation, because this question is regarding formation of agency. So use the word formation or formed or creation or created. How do you do an issue like that? Now, apart from the word formation, formed, creation or created, you must also have the method of how the agency is created. If the question is regarding implied appointment, then of course include implied appointment. If the question is regarding necessity, put necessity. Or if the question is regarding ratification, put ratification. And estoppel if the question is regarding estoppel. Alright, so how do you construct your sentence? This is how you do it. The issue in this question is whether there is formation of agency by ratification. See, the word formation is used here and the word ratification is used to show that this question is regarding, the issue in this question is regarding formation, and formation by what way? By ratification. Or alternatively, another way to construct the sentence is that you can say the issue in this question is where the agency by ratification is created. Remember here I said you can either use the word formation or form, creation or created, depending on the structure of your sentence. Now, so how do you write a full essay on that? Now, first of all, you have to start with your issue. As I said just now, you can write this way. The issue in this question is whether there is a formation of agency by ratification. So that's your issue. That's the first line that you should start with in your answer. The next step is for you to explain the law. Now, the principles of the law, what do you need to explain under principles of the law? Always start with the definition. What definition? Well, it depends on the question. Now, since this question is regarding agency, obviously you will have to start with the definition of agency. Section 135 of the Contracts Act defines agency as a contractual relationship between the agent and the principal, whereby the agent represents the principal in transactions, in dealings with third party. right? So you've got to explain what is agency, who is an agent, who is a principal, and then you explain the formation of agency and focus only on the relevant formation of agency in the question. Now, since you have already identified the issue that the question is on ratification, then focus your answer only on ratification. Don't waste your time explaining about other forms of agency. Don't explain about agency by necessity or estoppel and so on, because this question is on ratification. So you explain what is ratification. You've got to explain that agency can be created by 5 ways. One of the ways is by ratification. So what is ratification? You will have to explain section 149. You will have to explain the two situations where the contract of formation of agency by ratification can arise when the agent either he has exceeded the authority given by the principal, or someone who has never been appointed by the principal acted as if he is an agent of the principal. In that situation, the principal can approve. If he approves, then the contract of agency by ratification is created. Then you have to explain all the conditions for ratification. You've got to explain the conditions for ratification, support with cases. So this is the principles of the law, right? Explain the cases and support. Now, in your application, you have to use the sections, use the cases, use section 149, use the cases that you have explained, relate it to the question, the facts in the question, to show whether or not the conditions are fulfilled. So if there are any conditions that are not fulfilled, then the contract of agency by ratification cannot be created. So use the sections, use the cases. As we have seen just now, the question, the agent has exceeded his authority. So when the agent has exceeded the authority, if the principal approves, then the ratification can be created. But in order to ratify, the conditions must be fulfilled. And we have seen in the question just now, the agent ordered the goods using his own name. He did not represent the principal. He did not make the third party know that he's actually buying on behalf of someone else. And you've got the case to show that this is where the principal cannot ratify the action of the agent. So then you come to your conclusion. Conclude whether there is a contract of agency created, and if there is no contract created, then who will have to suffer the losses, or who will have to incur the losses or expenses incurred. Yeah, so this is how you write your essay. Of course, if you're answering question for agency by necessity or estoppel, you can still use these steps, but change it accordingly, and change the issue accordingly, and explain the relevant points of law, apply and conclude. Remember that you should focus your answer on the relevant formation of agency, and not explain the whole, or rather all the 5 methods of formation of agency, because you'll be wasting your time answering question. You're giving answers which do not actually answer the question. Now, moving on, if the question is regarding duties, now can it be the duties of the agent or duties of the principal? So this is something that you have to be clear on. Is it the duty of the agent or is it the duty of the principal? So read the question carefully and identify whether it is the duty of agent or principal. And which duties are relevant? Because sometimes in one question, there can only be 1 or 2 or even the maximum perhaps 3 duties which are being tested in the question. They will not test you on all duties of the agent, because obviously the agent has got more duties than the principal. Now, is there a breach of the duties? Did the agent or the principal breach the duties? And what is the effect of the breach of duties? So this is an example of a question. So let's go through the question. Betty instructed her agent John to sell her house at not less than 300,000 ringgit. David, an interested buyer, offered to pay 300,000 ringgit and in addition also gave John a bonus of 2,000 ringgit for ensuring that Betty sells the house to him. After Betty agreed to sell to David, she found out about the bonus that John received from David. She does not approve and did not want to proceed with the contract. Betty also wants to know what actions she can take. Now, here are some clues that you can see in the question. Now, Betty instructed her agent John. So this shows that Betty is the principal. It's clearly stated that John is her agent to sell her house at not less than 300,000 ringgit. So this is the instruction given to the agent. And in fact, there was a buyer who wants to buy it at that amount, which is not wrong. But what is wrong here is that the buyer asked, the buyer wanted to give a bonus of 2,000 ringgit to ensure that the principal sells the house to him. So this was not made known to the principal, and she did not approve. And she did not approve and does not want to proceed with the contract. Now, even though it says bonus, you should have in mind that this is not a bonus from the principal. It's coming from the third party. So this can be a form of a secret profit. All right. So moving on, how do you answer the question? So you must have these important keywords in your issue when you're writing your issue. So it would be good if you can put the word duties. Whose duty? Duty of the agent, or is it duty of the principal? So be clear on that. Next, it would be good if you can use the word breach. Breach means that a person does not fulfill his duty. So it's a breach of his duty. So how do you write your sentence for your issue? This is an example of how you can write it. The issue in this question is whether the agent has breached the duty not to make a secret profit. So you've got the word breach, you've got the word duty, you've got the word agent. Agent is the one who breached the duty, right? Secret profit is the relevant duty. All right. So this is one of the ways. Of course, there are so many ways for you to construct your sentences, but it would be good if you can go straight to the point and address what is the relevant issue in this question. So how do you write your answer? So this is the steps in writing your essay. So first you start with your issue. So you start your issue, you write your issue, and the issue in this question is whether the agent has breached his duty not to make a secret profit. Then you explain the points of law. You've got to explain the definition of agency. Always start with definition of agency, section 135. Then explain the relevant duty as well as the cases. So since this question is regarding secret profit, you've got to explain what is a secret profit. The agent's duty not to make a secret profit, section 168. Section 169, you've got to explain what is a secret profit and the remedies that the principal can exercise if the agent has made a secret profit. There are 5 remedies. You've got to explain them with your cases, support the explanation with cases. There's also, on top of the civil remedies, there's also, because secret profit is a form of a crime, it's also a form of corruption. So the principal can also take legal action for the crime that has been committed by the agent. He can lodge a police report causing and the agent as well as the third party to be charged for corruption, and also explain the consequences. Now then you come to your application. So in your application, you've got to use the sections that you have already explained just now. Use section 168, section 169, use the points of law that you have already explained earlier, the cases, to show whether there's a secret profit made. It's very important for you to show that you know what is the secret profit in this question. Even though the question says bonus, but that is not a bonus. It is a secret profit because this is something coming from the third party. It is not a bonus that the principal gives to the agent for his work done, but it's actually the secret profit that the agent receives from the third party without the approval of the principal. So you've got to show that you know this amount of money is secret profit. Sometimes the question, they don't just use the word secret. They don't use the word secret profit because they want you to show that you actually understand this is a secret profit. So sometimes they use the word bonus. Sometimes they use the word the incentive. Sometimes they use the word extra commission or pocket money. So you've got to know that if it's not coming from the principal, then this is a secret profit, and the principal can disapprove of it. So you've got to use the cases and the sections to show in the question that this is a secret profit, therefore the principal can take whatever actions. And sometimes it's not just one action, one remedy that the principal can exercise, because sometimes the principal can exercise more than one remedy. The principal can terminate the agent and at the same time recover the amount that the agent has made, the bribe that the agent has received. So you need to address the question carefully in your application to show which remedies can be exercised. And then of course you conclude by saying this is a secret profit, is a breach of duty by the agent, so the principal can take whatever actions which are relevant in the question.